Hello, everybody. This is TJ from urlaw.org, and this is our presentation about without prejudice. Can using it stop them dead in their tracks? Well, it's all about definitions, usage, and meaning, and that's very important you get this. And again, this information is for the void of legal advice. We're not rendering legal advice. Seek competent counsel, do your own research, and for gosh sake, look up words that we talk about before you ever use anything like this. Now, why without prejudice matters. Without prejudice is a powerful declaration and reservation of one's legal and lawful rights when signing any contract, receipt, application, form, or any document. The rule of thumb is that every single item you sign your name to almost always should include a reservation of your rights by including without prejudice. And it's not complicated. There's no secret way to do it, and it's got to be a certain color pen. It's about expressing clearly your intent. And once you understand the definition of without prejudice in the way we're talking about it, it can be very good to keep you from getting yourselves into voluntary consent. Because our entire legal system, you can talk about it being illegal, unfair, whatever, but it's all contract law. And if you don't get that before you start making your claim that something's wrong, you'll never win your case. It's because you voluntarily consented, and that's a maximum of equity. Equity will not aid a volunteer. You want equity? Don't volunteer. Or at least get what you need without giving away your rights voluntarily. This is key to the whole concept of without prejudice. So, for example, write this down. I hope you don't need a special guide or special document. You just need to understand the definition and go look up the definitions yourself in legal dictionaries, not just generally. And so if you're using without prejudice, when you're signing something, you would use typically, and this is kind of how I've done it most times. I've done it on my license and other things like that. And yes, I have a license, but I did it without prejudice, which means I get the use of it without the full liability of it. That's very important. So I'd write by : and notice it's John Henry Doe. Now, is that an all capital letter John Henry Doe? Or is that a John H. Doe or a John Doe? No, it's your full upper, lower name clearly written. Essentially, it can be a signature, but it needs to be clear. This is very important. That's the only trick to it. By John Henry Doe without prejudice. That's all I'm doing is expressing my full given name without prejudice. I'm not assuming full liability for certain things that might happen on this, okay? So make your intent clear. That's all you're really doing. You got to know this because they're going to challenge you on this. So when you, for example, I've done this several times on licenses and other things. I've had people say, well, you can't do that, or well, you can't sign your name that way, or why are you signing your name that way? I don't care, whatever they say, I say the same thing. This is one you got to memorize. If they stop you, say, my legal counsel says, oh, by the way, I'm not your legal counsel. You are doing your own research. You are your legal counsel. Okay, remember that. It's not because I said so. It's because you did the research and discovered it yourself. So again, if they say something, you say, my legal counsel says I must use this. And then you'd say, are you giving me legal advice? Now, whatever they say, they may bounce it around. They might argue with you a little bit and say, hey, sir, I don't want to argue with you. I just simply want to let you know that my legal counsel says I must use this. Are you giving me legal advice? Are you qualified to give me legal advice? 9 times out of 10, they back off at that point, and they accept whatever you give them. Very important. Now, by the way, if you do want to apply for credit or something like that, sometimes you don't use this because you're using your name to get the credit. But when you want to deal with something that could come back on you legally, in particularly like a contract or a ticket or something like that, then this is when you want to think about using this. You have to decide for yourself when it's appropriate. I can't always tell you. Definitions are critical. I have on my desk a Black's Law Dictionary. I'm pounding on it because you can't see it, but it's Black's Law Dictionary. I look stuff up all the time, and you'd be surprised how often the answers to your problems and your questions are right in this book. I use the 5th edition. You can use 4th or 6th. Newer ones tend to change things. It's kind of like newer Bibles. They twist things around differently. I don't trust them. I go with the traditional standard King James Version. It hasn't changed for 1,000 years, and I trust original words. So anyway, without prejudice. So here's how it works. Where an offer is made without prejudice, that's where you're offering it back to them, It's meant as a declaration that no rights or privileges of the party concerned are to be considered as thereby waived or lost, except so far as they may be expressly conceded or decided. So in other words, you can waive certain little things, but you're not giving up everything by signing this, because sometimes you do give up a lot more rights, like a bank application or something like that. Without prejudice, without any loss of any rights, in a way that does not harm or cancel the legal rights or privileges of the party. These are out of, see, I notice 8th is there. I don't like the 8th one. I like the 4th better. You can see how it changes. Acknowledged by Uniform Commercial Code. Now, I'm not saying you should use the Commercial Code. I really avoid that now. I used to kind of talk about it a little bit more, and I realized it's actually detrimental to bring it up. Like UCC, saying UCC 1-308. I don't want to rely upon their codes. I want to rely upon the words of the dictionary. So with that, so here's how it shows you that this means UCC 1-308 without using the UCC. Performance or acceptance under reservation of rights. A party with the explicit reservation of rights performs or promises performance or assents to performance in the manner demanded or offered by the other party, does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, and like are sufficient. So in other words, you can use without prejudice, under protest, you can use say under duress, whatever it is, something that qualifies your signature. This is called qualifying your signature. It puts a limit on what can be done with it. Your signature is your voluntary act. If you give it unqualified, you're waiving all rights, or you could be, and you don't even realize it. Stop doing that. Always qualify what you're doing. Other UCC references, because we are dealing with commercial law, even in criminal cases, unless there's a harmed party, then you can at least know these exist. But just know that these laws support what we're saying here, okay? Other Uniform Commercial Code references for state statutes, like the Hawaii Revised Statutes. And you see Volume 11, Title 27, Uniform Commercial Code, Chapter 490, Uniform Commercial Code 490, 1-308. Ooh, look how they slip that into the state codes. Performance or acceptance under the reservation of rights. So you're accepting their offer, whatever it is they're offering you, and you might not even realize it's an offer. Sometimes a judge will yell something, you say, "That's not an offer." I said, "Yeah, it is. I accept that without prejudice." They don't like that. Arizona Revised Statutes, performance or acceptance under reservation of rights. See, they want you just to respond and act affirmatively without qualifying. When you do that, you're consenting. Everything is voluntary. Everything is commercial. So the Indiana Code, Commercial Law Code, Section 26-1-207. Now, 207 is important because that's what 308 used to be. So the states have adopted this into all their systems. It's all commercial law. So remember, if you don't remember what does this without prejudice mean, just say it to yourself. I waive no rights. I reserve all rights. Yell this out loud when you're thinking about this. What am I saying? I waive no rights. I reserve all rights. Can you remember that? Even if you don't have this worded perfectly, you just need to understand what you're saying. It's a very important thing to put limits on how much you're volunteering for out there. By including without prejudice in a signature on a document, you're expressing your will, that's your desire, that's what you want. It is my intent to authenticate the document without loss of any rights and in a way that does not harm or cancel any legal rights, unless these rights are expressly conceded in the document. Now, I had this actually happen to me one time in court where I did without prejudice, and everything came to a stop. I'm telling you, this is not a joke. This isn't a light matter we're talking about here. It really matters. And they basically said, hey, he can't do that because even though he's signing, there's no way we can enforce it. They were basically saying that to me. And I go, well, what's wrong with that? I was fine with that. And they said, but there were a few things that I was more or less agreeing to, in this negotiation that was going on. I said, oh, and so the judge, very honorably actually, said, Mr. Mars, would you mind actually agreeing that you're conceding on a couple of these points specifically, and then the rest of your rights can be retained? And I said, that's fair enough. See, that was okay. That was okay. I was agreeing to something, but I wasn't waiving all things. And by signing without putting the qualifier in there, you're not only agreeing to what they gave you, but any and all other rights that might go along with it. Why would I want to do that? And we do it to ourselves all the time. We do it when we file a tax form or a W-4 or W-9. We're waiving things when we sign that stuff. Do it carefully. Be very, very careful what you sign, because you're waiving things. So I want to say, I do not waive any rights. It is my intent to not accept any legal prejudice of my person or legal personality. It is my intent to not apply any presumed legal personality. That means a legal person, or sometimes some people call this the straw man. I'm not assuming that. You see, if you want to put all these thousands of pages of documents when you can say it with 2 words, as long as you understand what it means, you can express your intent very simply. It is my intent to not waive any rights, such as legal duty that can be claimed against me. It is my intent to not adopt any special law. And by the way, that's what's going on. You're agreeing to a private contract. That's special law. When you sign documents with these commercial enterprises, these courts, these banks, these police officers, or whoever, you're entering into commercial contracts. Everything's a contract. A sentencing agreement is an agreement. A plea agreement is an agreement. Okay? So anything you agree to, you go to prison by agreement. It's my intent to reserve a private person status, the right to retain any commercial capacity to question the debts of the United States. See, they're trying to put the debts of the United States on you by your assent to it. That's what you're actually doing. And they're using your paperwork to make money. It is my intent to not accept estoppel on certain facts based upon any unspecified presumption. See, I've spoken about this recently, about the laws of presumption, how dangerous that is. Look up the word presumption. Oh my goodness, you need to know what that means, because that's how the whole system works. They presume because of your actions, not them. You can't blame them because you volunteer for something without realizing they're making a presumption and you're not rebutting it, or you're not correcting it, or you're not limiting it. It's up to you to do these things. Don't fall for the presumptions every time they put something in front of you. It is my intent to stop any other actor from asserting certain presumptions, such as, it is my intent to stop any other actor from asserting presumptions such as, I'm reading it again, that I have made some political decision that might be detrimental to my rights, that I have surrendered a capacity. In other words, I'm giving away my capacity as a man and assuming the capacity of some sort of surety for something. I don't like to do that. It's up to you. That I have abandoned my native state. You're joining the United States in the District of Columbia. That's a different zone. That's in Supreme Court law. Okay? Then the presumption that I am a federal citizen, a citizen of the United States, a U.S. citizen, or a United States citizen. You don't need to make claims to those things, but they'll offer it to you. Okay? Or that I have accepted or adopted any general purpose civil person or legal personality in relation to the territory over which the sovereignty of the United States extends. So I'm not adopting becoming the liable citizen person. They need you to do that. You can say that it's illegal for them to do that, it's immoral. No, it's not. It's an offer. And you accept it. What conditions do you want to accept? Do you want to accept it unconditionally or with conditions or with limitations? I always want limitations. I want to know what my options are. Okay, that I have made an entry into a place, a federal area where treason is not invoked by exercise of war powers. I don't want to deal with that. That's what they're doing. I have adopted a person. A person. A person's not a man, ladies and gentlemen. It's a thing. And that I will not make a claim for treason. That I have adopted a person in relation to the non-redeemable negotiated instruments that circulate as money. You see, when you're using their private reserve, private Federal Reserve notes, they're for persons to use. Well, at least they presume that you know that. So you're not adopting that position. I waive the right to, you can conduct your affairs without penalty, that's what you're saying. I have the right to specifically object to the use of Federal Reserve notes as money. You know, but if you're given no choice, sometimes that's what you have to do, but that's under duress, right? It's sort of a threat. That I have accepted or the inducement of the benefits of the dischargement of the use of the obligation or securities of the United States and Federal Reserve notes. You're not necessarily saying I'm unconditionally accepting that. You have to sometimes use it though, right? But you're not necessarily agreeing that you're becoming something that you're not. That's the point. That the use of Federal Reserve notes makes me subject to the jurisdiction of the territory over which the sovereignty of the United States extends. The United States sovereignty only extends basically, and I'm giving you a paraphrasing, the District of Columbia, some of the territories it owns, and some of the docks and places that it has purchased within the states. And it doesn't own as much as you think it does. It is my intent to stop any other actor from asserting certain presumptions. Remember that word's presumptions, okay? Oops, let me go back there. That I have adopted the territorial law beyond the bounds of this transaction. So in other words, this piece of paper is the only transaction I'm doing. I'm not being moved into some district that I don't belong in. That I'm territorially effectively connected to the United States, i.e. the District of Columbia, or any other territory over which the sovereignty of the United States extends. That I am a belligerent in relation to the United States as defined in 50 U.S.C. Appendix, Trading with the Enemy Act. I'm not that thing. I'm not the enemy. That I'm a beneficiary of something. I'm not claiming to be the beneficiary of something. I'm just not related to it at all. So I'm not assuming the obligations of securities of the United States or some corporate form or any public trust. I'm not going to participate in that. You guys go take care of that. It's your business. That's what I say. That I'm commercially insolvent. That I accept the forum actus that this is a federal, territorial, or corporate matter. That I have agreed to be bound to such presumptions because, for example, that place is a federal area such as Hawaii. HI is a postal zone. That's why when you use the two-letter code, you're agreeing by presumption. They can presume that you're agreeing to be called, referring to yourself as a federal area or in a federal area, and therefore they have jurisdiction. I use a full name, Hawaii, and no zip code. That's a good way to make sure it's clear. Just little things like that can create these presumptions, you see. That the consideration was in Federal Reserve notes, that I'm under the purview of Uniform Commercial Code. Okay? You're saying, I don't want to deal with those presumptions. That's not me. That I have adopted the capacity of an owner. That I am stopped from claiming rights in rem. That I have donated title to private property. That my property or rights to property are within the public trust. You're saying, I stop you from thinking those things. I'm rebutting those presumptions. How do I do it? Without prejudice is saying all this. That's why you got to learn some of these things. Now I'm going to try to say this without screwing it up, but identis vera colligatur ex multitudine signorum. Obviously that's Latin, and I don't speak Latin. Don't even speak French. Means true identity is collected from the multitude of signs. That's Maxims of Law from Bouvier's 1856 Law Dictionary. What does that mean? Multitude of signs. In other words, you're giving them lots of evidence by the things you engage in. And you don't call attention to it if you don't rebut the presumption. And without prejudice is one way to rebut those presumptions, but also you need to know why it affects that particular document. Then you're removing the multitude of signs. So there is no identity of a person between the man identified in the documents recorded in the public record, maybe some summons or subpoena or indictment, the state of whatever recorder's office, and the person of the citizen referenced sometimes throughout the Oregon Revised Statute. You're saying I'm not a citizen, I'm not that thing on the document. It's usually the wrong identity. It's an all capital letter name, or it's got a middle initial. It's rarely your full given name. And as long as when you say without prejudice, you say I'm not assuming all that. Okay? You literally say all this if you understand it and your actions match it. Your actions are just as important as what you write. Let me say that again. Your actions are just as important as what you write. So there is no identity of, you're saying, a character, circumstances, nationality, political status, citizenship, allegiance, privileges and immunities, territoriality, domicile, civil status, rights and duties, capacity, and hence civil person. You're saying I'm not even playing in the game, guys. All these terms. Are you a citizen of? Well, the character of your is this, and these circumstances say that this is this matter going on. Are you in this nationality? You know, so you have to rebut these presumptions. And when you do the without prejudice process, you need to keep all these things in mind. This is what you're saying. Therefore, there is no identity of any commercial status or contractual relations, because the man herein is herein identified does not contract in the name of the capacity of some resident foreigner, but only the man's own true name, first, middle, last. That's why I tell you to sign first, full, middle, and last. No initials. Initials is where you were trained in school to assume the liability, versus an all caps name or using initials, middle initials, missing a middle name. Anything that's other than the full given name is what we call a fiction, a legal fiction, a person, the assumption of the liability for that thing. And that's what's on their documents 9 times out of 10. Even if they put it all in there, there's something else that's going to be wrong, I assure you. It's almost always that way. You were given a name at birth, and then they turn around and gave you a business name. You got both. So you're not assuming that that is you, that thing on a piece of paper is you, that thing on that license with a middle initial or last name first. That's how they do it on there, last name first, and then middle initial, sometimes all caps, sometimes not all caps. What matters is they never use your full middle last, and even then it's still probably on a commercial instrument, so it still might be, by them, considered a fiction. You still have to be careful how you accept. But without prejudice, clarifies what you're saying. And this is why they don't like you to sign things this way. Too bad. That's not our problem. So it's all said by simply writing without prejudice, or like by, colon, full, first, middle, last, and I clearly write it. I don't scribble it so they can't read it. I want to be sure it's actually clearly using the full name, and with that comma without prejudice, or sometimes people write without prejudice above it. As long as it's clearly, it's willfully put on there with the intent of saying these things, then it can have that effect. Does that mean they're just going to back off and walk away? Not necessarily. You need to remind them that it's there without prejudice and that you have not waived any of these rights. And where's the production of an evidence that indicates that I agreed to waive rights when I signed without prejudice? It will have an impact on things. It might be incorporated with other things you do. But if you start with that you don't want to be, because the Bible says don't be the surety. It's telling you, sign without prejudice. And you'll be a lot better off in many of your legal affairs. Thank you. This has been from yourlaw.org, and this is for the void of legal advice.